Okay, dear colleagues, I think we can start. As you could hear this morning from the introductory speeches and also from the keynote speaker, our focus today will be on judicial scrutiny in times of emergency and also democratic scrutiny. And then in the afternoon, in working groups, we will discuss what was our approach at the national level. So bearing on mind that COVID-19 was one situation which was demanding new approaches from a side of the states, and now we are facing new crises, as it was mentioned this morning. We are facing crisis, energetic crisis, ecological crisis, economical crisis, etc. And we should try to learn what was the most important element of our experiences during the COVID-19 crisis. Of course, whatever was the approach of the states, the key element was separation of powers and also the role of judiciary in our national systems. As you can see from the case law of the court in Strasbourg, we already have judgments. One judgment is pending in front of the Grand Chamber, linked with Article 11. This is the Syndic organization, Association of Syndic from Switzerland. And there is also another judgment where a violation was found. It is a judgment against Malta on Article 3. So we are experiencing new times, but also new developments into the case law of Strasbourg. I have special honor to introduce three of my distinguished colleagues during this panel. We will start with Judge Anja Seibe-Foch. She is elected for Germany in front of the European Court of Human Rights, but I must say that I was pleased to meet Judge Seibe-Foch as a member of the Commission on Human Rights in the United Nations. So Judge Anja, your experience and your knowledge from Strasbourg will be of crucial importance for us to start this, let's say, more professional debate. The floor is yours.
Thank you very much. Distinguished judges from the region, dear fellow colleagues and ladies and gentlemen. I'm very pleased, thank you very much. I'm very pleased being here again. It's my third time at the forum, which has become very dear to me because I think this offers a unique opportunity to engage in a dialogue with the highest courts from the region, which I find very important for our work. Now, when you read the title of this conference, you may have been somewhat annoyed. At least I thought, oh, COVID-19 again. Aren't we across it? And aren't we moving beyond all of that? On the other hand, I think what the previous speakers have already explained is that there are some lessons to be learned. And you also need to know that the COVID-19 cases are only coming to our court because of the exhaustion of local remedies. So you may have just finished dealing with your COVID cases when we only start. And I think a very important lesson that can be drawn is the importance of the judiciary in this undertaking. And I would like to come back to that later on. Before I come to some more general lessons, I think I should go back in time a little bit, 2020, because soon after the pandemic broke out, 10 participating states of the Council of Europe, amongst them Albania, but also North Macedonia and Serbia, declared a state of emergency and derogated from the European Convention of Human Rights. The Estonian notification explicitly referred to due process rights to be limited on the basis of Article 15. Others, such as the Serbian note, did not refer to any specific article. The vast majority of European states, however, did not formally derogate from the Convention, but argued that the Convention standards needed to be interpreted in the light of the particular situation. In its jurisprudence so far, our court has accepted that even without a formal derogation, during the early, most dangerous time of the pandemic, the exigencies under, for example, the right to liberty, but also the right to take proceedings against detention and due process rights were not necessarily exactly the same as in ordinary times. The court noted that the pandemic was liable to have very serious consequences and recognized the exceptional and unforeseeable nature of the situation. My colleagues on the panel will explain in more detail to what extent our court has allowed certain exceptions from normal standards, ranging from delays in judicial proceedings over the course of video conferences that we have become so acquainted with, to the exceptions from the applicant's attendance during administrative court proceedings. Let me therefore turn again to the issue of permissible derogations. In respect of states that have formally derogated from the Convention, it is important to note that though Article 15 in principle allows derogations to be made from due process rights in times of emergency, such derogations do not give carte blanche. In Piskin versus Turkey, for instance, the court found a violation of Article 6 despite the fact that Turkey had made a formal derogation from the Convention following the attempted military coup in 2016. The court was seized with the question whether the limited scope of judicial review could be justified by the emergency situation. Despite certain permissible limitations to due process rights, the court emphasized that the rule of law must prevail even in times of emergency. Though restrictions could be placed on judicial review in such situations, this requires a clear and explicit wording to this effect in the relevant legislation. Absent such provisions, domestic courts continue to be authorized to exercise sufficient scrutiny so that any arbitrariness could be avoided. And we've heard this morning about one of the examples. While this case did not concern the pandemic, the court's holding is of course not limited to situations of criminal coup, but applies to any crisis, regardless of whether the emergency originates from insurgencies, terrorist attacks, from a health crisis. The court has defined public emergency as, and I quote, an exceptional situation of crisis or emergency which affects the whole population and constitutes a threat to the organized life of community of which the state is composed, quote end. So far our court has applied Article 15 with respect to terrorist attacks in Ireland in the 1950s, late 1950s, the threats posed by the Irish Republic Army, the IRA, in the early 1970s, the PKK terrorist attacks in the southeast of Turkey in 1990, and also the terrorist attacks following from the attacks on the World Trade Center. As we can see from the case law of the Strasbourg Court, the rule of law is thus imperative regardless of the reasons leading to such a state of emergency. Measures of emergency must be strictly required by the exigencies of the situation, which is stipulated in Article 15, paragraph 1. That judicial review is of utmost importance with respect to any limitation of conventional rights has been repeatedly stressed by the court. In Wawrzyka versus the Czech Republic, the court recognized the importance of judicial review as a factor to be taken into account in the proportionality assessment. This case concerned the statutory duty to vaccinate children with standard vaccines. When examining the proportionality of this measure, the court referred inter alia to the availability of judicial remedies to challenge the legality of any sanction for the non-compliance and to obtain compensation in case of health injuries. The need for judicial review also applies to emergency situations, of course. As already indicated, while the court is ready to accept certain adjustments of the applicable standards for judicial review, it does not allow states to dispense with judicial review at all. Quite to the contrary. The importance of judicial review in times of emergency should not be underestimated, not only as a matter of upholding the rule of law, but also as a matter of subsidiarity. Let me explain this a little bit further. As indicated before, the court has recognized the COVID-19 pandemic as an exceptional circumstance in which states have a legitimate interest to take sanitary measures to prevent the spread of the disease. The court has left states a margin of appreciation in the choice of such emergency measures. Nevertheless, these measures need to be proportionate. This is why domestic courts continue to play a crucial role in times of crisis. The balancing of rights depends on the particular situation at hand and the health situation in a country, a situation that we are often not able to assess from Strasbourg, not only because we do not live in the region, but also because of the time lag in between. So while the Strasbourg court lacks fact-finding capacities, domestic courts, to my mind, are much better equipped to engage in a balancing exercise, taking into account the particular situation at hand. The review by domestic courts therefore allows the European Court to better understand the factual circumstances, a precondition for any balancing required under the Convention. It is for this matter that in its analysis, the court often takes account of the judicial review exercised by domestic courts. In several cases concerning the pandemic, the court has concluded that in light of the careful balancing undertaken by domestic courts, no violation of the Convention could be found. Most of these judgments show that it would require an obvious imbalance or ignorance of basic principles of health protection before Strasbourg Court would intervene and substitute domestic decisions by its own assessment. It is only in those cases when domestic courts fail to exercise their proper supervisory function that the court will intervene. As I said beforehand, this does not give the states parties or domestic authorities carte blanche, but if we see that there is a serious engagement with the rights and a balancing, taking into account the various factors that characterize the situation, I think the jurisprudence of our court shows that we will not intervene as a fourth instance, knowing everything better than the domestic judges. So to sum up, judicial review is of utmost importance, not only in ordinary times, but also in times of emergency to uphold the rule of law. Regardless of whether states have derogated from the Convention or not, they must not dispense with core principles of judicial review. In case of restrictions on conventional rights, meaningful judicial review needs to be available. Such review ensures that states do not abuse their emergency powers. Understood this way, the availability of judicial remedies is a necessary precondition for the guarantee of fundamental rights protection in Europe, also in times of emergency. I would therefore like to emphasize at the end that you, as domestic judges, play a central role in this undertaking. Thank you very much.
Thank you, Judge Saber-Foch. Thank you very much for starting with derogation because, as we all know, 10 states were derogating from some articles of the Convention during the crisis. And yes, indeed, the court was experiencing the process of derogation and the duty of the national courts to establish judicial protection even during the emergency and even during the war situation or terrorist attacks, as was the case in Ireland or in the case of Cyprus versus Turkey, Aksoy versus Turkey, and etc. So thank you very much for making this clear link between the importance of judicial review, no matter is there a derogation or the state was not derogating from the convention. And now we have with us via video our distinguished colleague, judge elected for Sweden in front of the European Court of Human Rights, Erik Wennerström. Erik, welcome to this gathering via video. We are so sorry that you are not with us. And your contribution will be extremely important because you will also speak about the meaning of effective judicial review during the time of emergency, but with the focus on the requirements of Article 6. I know that you have been at the composition of the Judicial Council who was deciding many important cases linked with the independence of the judiciary, and today we were talking about this element as a requirement of Article 6 as well. So I will give you the floor, and please give us some more elements for truthful discussion today. The floor is yours.
Thank you very much. I hope you can hear me. Let me thank you for this introduction and tell you that I'm likewise sorry not to be able to be there physically. I think building up on what the keynote speaker said earlier today, the pandemic has reminded us of the importance of many things, including solidarity in our societies, the importance of judicial systems, of social protection systems, and of well-functioning health systems. The pandemic is also a challenge for human rights and the rule of law, as it puts pressure on all Council of Europe member states to fulfill their positive obligations to protect life and health, obligations which we find in a sort of description of the social contract inside the European Convention in Articles 2 and 3, while maintaining their respect for their obligations under Article 6 and its lex specialis in Article 5. Now, as was just pointed out, the contracting states have the right to derogate from the convention under Article 15, and some of them did, as the previous speaker outlined. This must naturally be strictly necessary in view of the exigencies of the situation and compatible with other obligations under international law. States have been given a wide margin of appreciation in this area, but all exceptions may ultimately be judged by this court, ensuring that the exceptions comply with the principles of legality, of limited duration, and comply with necessity and separation of powers, notably the legislator's control of the executive in times of emergencies. Balance is the key, and it is surely in the search for this balance that the Council of Europe, together with the convention system, its participating states, and the European Court of Human Rights are on the front line. Now, turning to the judicial security in emergency situations and measures, it's worth noting that additional European standard-setting bodies issued relevant guidance here early on in the pandemic. Apart from the very useful and timely toolbox that was issued by the Secretary General of the Council of Europe during the first weeks of the pandemic, the Consultative Council of European Prosecutors prepared an opinion in 2020 on the role of prosecutors in emergency situations. The President of the Consultative Council of European Judges issued a statement also early on in the pandemic on the role of judges during and in the aftermath of the COVID pandemic, and which underscores that the principle of the independence of the judiciary should not be called into question during a pandemic. The European Commission for the Efficiency of Justice, CEPESH, made the declarations also in the early days of the pandemic to provide us with guidance ahead of what was to come. Now, the Strasbourg court had already, well ahead of the pandemic, made certain fundamental principles clear, notably in, for instance, in Shelley versus the United Kingdom from 2008, which I quote, matters of health policy, in particular as regards general preventive measures, are in principle within the discretion of national authorities, unquote. I look at Kiyutin versus Russia from 2011. I can quote that travel restrictions are instrumental in protecting public health against highly contagious diseases with short incubation periods, unquote. So the court had already elements of jurisprudence well ahead of the outbreak of the COVID pandemic. As my colleague Anja Seibert-Foh just mentioned, the Grand Chamber case of Wawrzyka versus the Czech Republic held that these positive obligations may very well include the implementation of mandatory vaccination policies, which was the main issue in this case. If national authorities determine that voluntary vaccination is not sufficient to achieve the objective, which is usually herd immunity, the applicants had also claimed to have been denied an effective remedy against their grievances with the obligatory vaccination regime. Concerning this, which was dealt with during the proportionality consideration of the court noted that the domestic proceedings brought by the applicants showed that they, and I quote, had at their disposal both administrative appeals as well as judicial remedies before the administrative courts and ultimately the constitutional court. And I go on quoting, the fact that neither applicant was ultimately successful in their constitutional action does not diminish the significance of this jurisprudential safeguard of fundamental rights, unquote. Now, the sanitary precautions which states did put in place in response to the pandemic did create challenges for the continued functioning for the domestic justice processes and the judiciary. There were restrictive measures that did risk impeding proceedings and administrative processes. Such measures were taken as meaning that meant that those being held in pre-trial detention were faced with the potential prolongation of their deprivation of liberty. There was also a shift towards digital solutions in response to the challenges facing the justice sector during the pandemic, which raised questions as to infrastructure and equal digital access, as well as, the more fundamental issue of whether these solutions were fully compatible with the convention rights. The court had already occasion to examine some of the issues which may arise in this context, although, as the previous speaker noted, we are still only in the early days of dealing with whatever cases the pandemic may bring to us from the national systems. Concerning the right to liberty and security under Article 5, the case of Teres versus Romania concerned an applicant that was a member of the European Parliament, staying in Romania at the time of the events. A lockdown was ordered by the Romanian government to deal with the pandemic, which included restrictions on leaving one's home. Now, the applicant claimed that the lockdown imposed, which had been forced to follow, was a deprivation of liberty. The court declared the application inadmissible, which ratione martyria. In particular, the court held that the measure complained of could not be equated with house arrest or even deprivation of liberty. The decision in Ba versus the Netherlands, however, concerned the impossibility of the applicant, who was a foreign national, to be heard in his immigration appeal in person or even by tele or video conference due to the initial infrastructure problems that several countries faced during the earliest days of the pandemic. Now, the court again declared the application inadmissible, being manifestly ill-founded, as the applicant had in fact been entitled to take proceedings within the meaning of Article 5, and that the circumstances of the case, those proceedings did meet the requirements of that provision. Here again, the court noted in particular the difficult and unforeseen practical problems that the state had been confronted with during the first weeks of the COVID-19 pandemic. But also the fact that the domestic courts had made concrete efforts to enable the applicant's presence at his hearing, and had explained in detail why it was not possible to hear him. I should also mention a decision in the case of Fenech versus Malta, which again the court declared inadmissible, at least partially. The case concerned the aftermath of the applicant's arrest on suspicion of involvement in a suspected case of murder. The arrest took place in 2019, but later, the next year, national measures were introduced to counter the pandemic, which led to temporary suspending of criminal proceedings. Now, the domestic courts retained discretion to hear urgent cases or related matters, and the proceedings did overall resume 3 months later. The applicant's complaints, which were lodged under Article 5, were manifestly ill-founded. One of the reasons was seen as the temporary suspension, which had been due to exceptional circumstances, which, as the Maltese Constitutional Court had held, had justified such lawful measures in the interest of public health, as well as that of the applicant. In a very different type of reasoning, this is the case of Q&R versus Slovenia. This is an older case that started events starting well before the pandemic, but it concerns civil proceedings for foster care, proceedings that had lasted approximately 6 years, and the length of which was found to be in breach of Article 6. Even though some of that length had been partly due to the pandemic-related measures in Slovenia, although the lion's share of the delay was not at all related to the pandemic. The 4 different applications in the still undecided case, Atufella and others versus France, concern the adaptation of certain rules of criminal procedure on the basis of pandemic-motivated emergency legislation. Now, this adaptation included the automatic extension of periods of pre-trial detention. So the 4 applications were received from individuals who were in custody at the time, and they complained that their detention has been extended without any decision by a judge, referring mainly to Article 5 and in its different paragraphs. Now, this is still an undecided case, but it demonstrates what type of issues that have reached us in this respect so far. Now, in conclusion, let me say that the pandemic triggers a series of classical types of human rights issues. That is to say, individuals complaining about measures taken by public authorities that allegedly restricts the freedoms more than the convention allows. These issues are already being examined in many cases in courts in the Council of Europe member states, and as you've heard, in some cases also before the Strasbourg Court. Now, what we have seen from jurisprudential development so far suggests to me that the essence of effective judicial review during times of emergencies is no different than during normal times. But the preliminary conclusion that may be drawn from the cases we have seen so far concerning judicial review, the Articles 6 and 5, is that bona fide measures modifying the duration and the location of review mechanisms and their procedures can be compliant with the convention, provided that they are based on legality, necessity, and proportionality, as well as of limited duration. Now, the particular circumstances during the pandemic goes into this equation. It is an exceptional circumstance, but it does not require a different equation. And it does not, according to the vast majority of state parties, require derogation. There is and was already case law making this clear and possible. With this, I thank you.
Thank you very much, Eric. Indeed, this long list of cases that were already decided by the court is just the beginning of the new cases which are already communicated, that will have to be decided by the court, and they are already communicated to the states. Yes, you are right, many of the rights which are protected by the convention were already let's say, challenged by the applicants in front of the court in Strasbourg. And as it was already said by the court in the decision of Saakashvili versus Georgia, it was difficult time for the applicants because during the pandemic, it was difficult to access the court files and also to access courts as one of the rights guaranteed under the Article 6 as well. So no matter how soft the messages look in a form of inadmissibility decision, yet they are important for the judiciary and for the judges. And margin of appreciation, it does apply in a situation of emergency, but it does not allow states and especially judiciary to look above the cases with less scrutiny. So thank you very much, Eric. Please stay with us because now we will have opportunity to listen our colleague from hosting country, Darvian Pavli. Darvian is a judge in front of the European Court of Human Rights in honor of Albania. And Darvian, you will probably give us more elements from the rights and freedoms that were already challenged in front of Strasbourg. I was looking into the statistics of the court and I could see that there are already cases covering almost all articles which are almost all rights protected by the convention. But also I noted that there were more than 300 requirements for interim measures during the COVID situation. So please, the floor is yours and give us some more elements from these difficult times for our courts. Thank you.
Thank you, Mirjana.
Thank you, Mirjana. Hello once again. Allow me to start by thanking and actually by expressing my pleasure that today in this meeting we have judges and from Albania and from the region. We also have a very good group of judges from Strasbourg, from other countries of Europe. This is for me important for two reasons. First of all, this conveys, let's say, their very valuable this gives us their valuable perspective. They are part of the panels which take decisions, you know, on the cases coming from our region. At the same time, I also believe this is a very good opportunity for them to be able to see the perspectives of their colleagues from the High Court or Constitutional Court from the region, the way they perceive Strasbourg decisions here in the region. So this is a win-win situation, I would say. I will try to summarize many of the cases judged by the court. My two other colleagues spoke about them earlier, but I'd just like to clarify, let's say, some points which I already mentioned in my morning speech. So this institutional superstructure and certain issues which are, related with how courts function during a pandemic or during other types of emergencies and the effects they have on fundamental rights. I would also like to address some more aspects about, restrictions of other rights, like political rights, during these situations. Regarding the first topic, I mean checks and balances, the balance between different powers. What is most important is what was already mentioned this morning, that is the Swiss law, Communauté Genevoise, which was decided by the in the third session together with Anya. I was part of the panel. This was a 4-3 decision, and maybe it's not really a surprise for you. This was referred by a request of the Swiss government. It was referred to the Grand Chamber. I'm not going to refer to the content of this decision. The case is now with the Grand Chamber of the court. Everything will start from scratch. But I'd just like to address some of the, issues. This was an almost absolute restriction of the right to rally in Geneva canton, almost an absolute restriction through a legislative decree. So one of the aspects is this was an executive decree. So the question is whether there was any kind of legislative scrutiny and judicial scrutiny, because this is certainly about the rules, for getting a permission for a rally, and the organization in question, which is a trade union in this case. They wanted to organize something on the 1st of May, as the tradition goes for the Labor Day. So they claim that this restriction was so absolute that it made no sense to apply for a permission, because it was clear that they would not get one. And this, continued in the different instances of court. And in the end, the Swiss High Court, well, that is after the 1st of May, the Swiss High Court refused their, request, saying that there was no longer a legitimate interest, for such permission. The 1st of May, on which the trade union wanted to have this rally, was already, behind. So I believe this is going to be one of the elements to be analyzed. So to what extent, to what extent there was there some kind of scrutiny, if the court, reviews the merits of the case. This is just as an illustration. We will have to wait for the final court decision. However, these are some of the elements. I might similarly mention also another decision, and this is a decision of the Constitutional Court of Kosovo. I believe we have at least 2 colleagues from the Constitutional Court of Kosovo. We have had the pleasure to have them visiting the European Court recently. And if I'm not wrong, there has been a rejection of an executive decree because there was not enough sufficient legislative authorization to limit rights through such an executive decree. This was my first set of considerations. Secondly, about the functioning of the courts. Well, many of the previous speakers mentioned this, like my colleague Eric, the Swedish colleague. He referred to Bach, case, which is about guaranteeing procedural rights to a person in pre-trial detention, a person who was an immigrant, an immigrant in pretrial detention. As mentioned, the court referred to the extraordinary situation of the pandemic. The court also recognized the lack of scientific knowledge about the risk and how to prevent such risks. So the court admitted that in this specific case, even though the person himself had not been able to be present in the video session organized by the court, the court recognized the fact that his lawyer had been present. So the applicant had actually had an opportunity to consult, let's say, his lawyer. So the court considered this as, sufficient for Article 5, which is not always as strict as Article 6, the due legal process in cases of judge, court reviewing the merits of the case. I would also refer to the French legislation. There was an important precedent by the Constitutional French Court. There was also there have been also other similar cases before the European Court regarding the French legislation, especially the automatic postponement of pretrial detention periods. My colleague referred also to some efforts, let's say, to generate some kind of actio popularis before the European Court, especially in Zambrano case. This was an academic who created, let's say, a form in order to overwhelm the court, with thousands of applications from France. So with identical forms, the court did not consider them acceptable. The court considered that as abuse. Given that these people had never proven, that they had been directly affected, let's say, by the restrictions they challenged. And this was different types of restrictions, like restrictions on police forces or fire brigades. So the court took a decision, to reject these applications as abusive, as they go against, let's say, the basis of application in the court. You have to prove that you have been directly affected by what you claim, was not legal. So that was a kind of an automation of the application process, which, as I said, the court found abusive. Regarding the third topic, that is the general restrictions on rights, like the right to movement, the right to rally, the right to rally in public or private places, or political rights. This was so common all over Europe, maybe all over the world. So, and this is maybe the richest, let's say, part in terms of jurisprudence, both at the national level and especially at the national level, but also at the international level, which is a bit more behind, for reasons we all understand. Cases in Strasbourg always arrive a few years later because, of this requirement to exhaust first the domestic, domestic system. So the jurisprudence of Strasbourg is still limited, I would say, for the moment. We hope that in the coming years it will get enriched, and I'm talking about the cases related specifically with the pandemic. Of course, we do have other valuable decisions, but when it comes to this specific situation of the pandemic, there are still cases which are pending. We're still behind with that for certain reasons. And I believe there are other cases which will be decided in the coming years. However, in my opinion, this also confirms widely known fact that the first line of protection of fundamental rights is not the European Court, it is the national courts. So if we look at, if we take a superficial look, let's say, at what has happened, we can clearly see that the national courts have played a very important role. Some of the cases were already mentioned, like the case mentioned by Mrs. Tusche. She referred to the jurisprudence of the Albanian Constitutional Court. The Slovenian court also had a very similar case. They rejected some restrictions for because such restrictions had been imposed without any specific, deadline, without setting any date. So this was some types of indefinite, restrictions, not subject to any kind of scrutiny.
The Bosnian Constitutional Court dismissed also the basis of proportionality some limits that targeted only some age groups, minors and persons above 65 years of age that could not leave their homes. They were very strict limitations of the right to movement. It suspended them and asked for further explanations by the executive regarding the rationale of such limitations that affected more some specific social groups. And finally, not to take much of your time, since the moderator mentioned that it might be of interest to inform you of some of the cases that have been decided by the court. It's a case versus Greece, or two cases versus Greece, related to the protection of inmates or the pre-detainees that are infected with HIV virus and a specific issue facing them. The French case was mentioned by Eric Aitofelan regarding the default postponement of imprisonment. There are two interesting Serb cases related to temporary limitations of the freedom of movement of persons that had the status of refugee or asylum seeker or immigrants, IBE against Serbia and AA against Serbia. You find the details in the materials, the written material I presented to the organizer. You can refer to the details there. Another case from Bulgaria relates to 10 and 11 articles of the convention, Petrova versus Bulgaria, which involves an ordinary person who had made critical comments in the social media against some of the limitations that she considered excessive. And the police visited her in the city she lived and warned her. She had also appealed for protest. They warned her not to protest. They summoned her to a police commissariat, and they opened some criminal proceedings against her. It was a case that was communicated to the Bulgarian government, warning it against such interventions when persons, express their views in the social media, which are in compliance with Article 1011 of the Convention. Thank you once more for your attention. If there are questions, I would gladly answer them.
Thank you very much, Darian. Yes, you are right. We are at the beginning, probably, of a new approach when it comes to the cases which are deriving from this form of crisis. And thank you for recognizing the role of the national courts, because this is extremely important. You've mentioned the Constitutional Court of Bosnia, of Kosovo, of Slovenia, but all our national courts, Supreme and Constitutional courts, were trying to accommodate to new circumstances, and in many national courts the doors were open during the crisis, despite the fact that the physical contacts were probably dangerous for the people who were working in the courts. So I would like to ask you, dear colleagues, participants to this plenary meeting, if you would like to ask questions or to comment something in connection with our colleague Anja Sieber-Pope, because she will have to leave soon. And please feel free to start discussion with posing questions or comments to her, and then we can continue. Is there someone who will like to break the ice to start the discussion? If not, Anja, would you like to add something before you will leave us? I know that in a few minutes you will have to leave and we will stay a bit longer.
Okay. Just to thank you very much for having me invited over here. I very much regret that I won't be able to continue in the ongoing discussion. Hopefully next time I will bring more time with me to engage in that. But I think the most important thing that we can learn apart from the COVID is that it is very crucial to have this dialogue with the domestic judiciaries. It's not that everything, we have talked about the serious, the tremendous workload of the European Court of Human Rights. We have 75,000 cases pending right now. Who are we without you as domestic courts who engage with the convention, who do the balancing and so on, if we cannot deal with all COVID cases? So I think it is very important to have this dialogue in order to, on the one hand side, receive the information that you give us, on the other hand, that we feed that back into the domestic judiciaries. And therefore, I think beyond the COVID crisis and apart from future crises, I think we should keep on this dialogue. Thank you very much.
Thank you, Anja. Yeah, I agree with you. Dialogue is the crucial, and that's why we have these forums in this region. Through dialogue, we can learn from each other, and also we can probably discover what are the problems, why the judicial scrutiny was good or bad during the pandemic time. And I see Judge from the Supreme Court of Serbia, Radmila Dragicevic. Radmila, please.
Thank you. I don't know, shall I talk on Serbian or English, or I don't know. I can talk on Serbian, yeah? Okay, hvala. Pa, Srbija je imala već jedno iskustvo vezano za... You have translation? Okay.
Then continue with English, and as soon as the colleagues will have you can switch to Serbian.
Da nastavim?
You are very good in English. Yeah.
Okay. Uključena sam, da, ok. Da li sada ima prevod? Okay, I can talk in English then, huh? Okay. Dobro, hvala vam. Pa, htjela sam samo da kažem da ja sam sudija Vrhovnog kasacionog suda iz Srbije i žao mi je što ovde nije ni predstavnik Ustavnog suda Srbije, koji do duše nije imao neku značajnu praksu vezano sada za ovu situaciju pandemije COVID-a. Ali ću krenuti od toga da se Srbija suočila sa nekim, odnosno ne nekim, nego vanrednim stanjem po prvi put u značajnoj meri u martu mesecu 2003. nakon ubistva premijera doktora Zorana Đinđića, kada je uvedeno vanredno stanje odlukom Skupštine.
Prime Minister, when we had the measures imposed in our country that were lasted for 42 days, and this state includes the action called SABRE, that we have the measures that we have 11,000 people detained, and within these measures and these acts we have different measures that later was denied, but soon they were denied by the side of the Supreme Court of the Republic of Serbia, and the decision about this extraordinary time was not denied, but some of the measures were denied that were according with this decision, and I think that was justified because they were concerning about the limitation of the freedom of press, freedom of public speech, and freedom according to the action of the police, and then the most drastic measures that was denied, and after that, that was a subject of let's say about the different courts that they were talking about the measures of detention of the suspect up to 30 days with a very restricted approach from the attorneys, because that we have in our constitution it is about 48 hours, and this is according to the standards, but we are talking about the 30 days right now, and we have the limitation of the rights of strike, and the director of BIA was he has the right to deny the rights of reading the letters and the secrecy of the communication. So these measures, maybe there were some more measures, but my colleague is here, maybe he will add something after that, but these decisions was denied, but they were shown that they are against the constitution in our country. But the biggest problem was this with the detention that lasted up to 30 days, and the public was very concerned about it. That had very big influence on public, and these measures were not good. And after that, we have more cases for questioning this decision on the ordinary course. But when we are talking about the pandemic and working of the courts, regular courts, from the aspect of the law, the approach of the court, to me, as a judge, it is a very important question, and that also became a global question. And somewhere in these decisions, before the ordinary courts, and in front of the Supreme Court that took decisions of the law, we have questions that are connected. Let's say in front of we are not talking about the Supreme Court. Then this is all. This is the assignment from the Supreme Court. But we are using the practice from the European Court. But we have problem with the trial through the video links that was not known to our lawful system. But the problem was approaching to have the right on the attorney. So because there was a question about do we have, because if we are talking, if the attorney is not together with the suspect who has given his statement before the court without the attorney, so we have the question, is this right? And the right for the relation in between attorney and the suspect. So that was not according to our law. Some of the cases are still ongoing, and I think the positive side of the attorney's chamber, they said at one moment they would refused to go in this type of trial, to be present in this kind of trial, and that's why we have postponed this kind of trial. So that was the first reaction from the defense, from the attorney. The question that was very interesting for the Supreme Court, because I'm working with the criminal law, but the question was the verdicts that the people who has punished for the violation of the rights of movement, and we have included as in our judgment practice that we have denied a lot of this kind of verdicts, that we have the verdicts that give people, we have denied these verdicts, and we have established that these people was found guilty for not respecting the measures for the protection of the health in the situation of pandemic. So we have two kind of laws. We have one kind of law. I mean, this one is about the extraordinary measures, one of the protection of the public health. But we have established that people at the beginning, okay, we are talking about the massive punishment at the beginning from people who are coming into Serbia from the other countries, and they're not being informed about their obligations at the beginning of this kind of measures. They do not have the decisions personally delivered to him, everything what is concerning the health conditions. That the movement was restricted, let's say, for the 8 days or two weeks, and they were just, the verdict was based on some blanco papers that they have not signed for, but the assumption that they needed to know that there was a danger, that they will spread this disease, that they are coming from the countries which are under big risk. We have some. And we have worked on based on the other laws. And that was based on that they needed to be informed. And in this case, I think that this meeting is very important, because we are talking about the politics and about the popularity of the politics that's supposed to have some influence on courts, influence on decisions, and we're thinking that this is a very great danger that let's say we're talking about the Supreme Courts, when we're talking about the Constitutional Court, that we have to take care of this, that we don't have the influence, and this is not especially easy when we are talking about some not ordinary measures or restrictions. In Serbia, we have this, let's say, this restrictive measures that there was denied. The freedom of movement was denied. That lasted more than a month, I think. Maybe lasted, let's say, for more than 2 months. The younger people know better because they have more difficulties about this. Lasted for 2 months. And after that, that was spreading for the elderly people, and let's say we didn't have the adequate answers on these questions. But these measures, we had these measures that the numbers were, let's say, we had the very small numbers of the infected people. And after that, we came to the 1,000 of infected, and then we didn't have the same measures in power. But now, when we are looking back, what was the reactions of the different states? Were they justified or not? This is the question that maybe, let's say, maybe in future we can analyze this in this light. Thank you, Radmila.
Thanks for sharing the Serbian experiences with us. It's very important. Everything you said is basically related to right to fair trial, Article 6, and you yourself said you were thinking about that even though the court was preoccupied with the constitutional jurisdiction, that the right to a fair trial is what led you in your decision making, even though you had an option for online trials, but you were thinking about guarantees from Article 6 of Convention. I see Vanya wants to ask a question or give a comment from Montenegro.
Lazareva. I also want to introduce about some situation in Montenegro, and I will speak also in our mother tongue because I want to be very precisely.
So, as our colleague Rada Dragicevic has said, all of us in the region, and without a doubt in all world, we have met this situation the pandemic brought to us. But what I want to share with you today and to let you know about maybe a specific situation we have had in Montenegro, and that we have hopefully stopped on a national level in order not to have submissions towards Strasbourg. So at the very beginning, in March, when coordination bodies were established to manage the crisis, there were absolutely identical situation, prohibition of movement and so on. So our judicial bodies interpreted these provisions, which were amended every 24 hours. It was interpreted exclusively from the point of view of criminal legal protection, in the sense of criminal code. It was not interpreted as a civil misdemeanor or whatever. At the very beginning, we had very restrictive measures about detention, which were implemented in a specific rooms. They were prepared for persons that were to be sent to detention. Further, with regard to prohibition of movement, it was exclusively interpreted, as our colleague said, through a criminal code. So people were sentenced for crimes. Still, there was some pause with processes. Some decisions are final, but as the time had passed and our judicial bodies recognized that it was not the final idea of interpretation of these provisions, so they kind of stopped. However, we have had a situation that our coordination body, at one moment when, you know, there was hourly informations on number of people infected, and our coordination body had decided to publish the list of all persons that were COVID positive. That list, with certain number of persons, several hundred or maybe thousand, was published on our website of our government, and along with the warning and some reaction from civil sector at that moment or whatever, they remained consistent, so the list went public. Very quickly, it was pulled off, but all social networks forwarded the names and everything, and what happened? These persons were targeted. You know at that moment what that meant. We have all looked who is on the list so you could avoid their part of the town or the neighborhood or whatever. Once it finished, all these citizens have sued the state of Montenegro for damages of non-material damages, for violation of their right to privacy, and so on and so forth. And at that moment, one of our basic courts was overwhelmed with a number of submissions of lawsuits. So this is where we have done, maybe for now, a good thing. You know, once you sue the state, there's a protector of property interests representing it, and in some trials I was participating, and I have suggested for the defender, the public defender offers a friendly settlement, and we as a state would accept responsibility and pay certain damages. So it went at that level. It's not done finally yet. There's so many suits, but on that level, that's done. So I don't want to give anything in advance, but if we didn't do it in that way, it would take too long and everything would probably, all the suits would be resolved maybe positively, except maybe some for some procedural reasons, but the state accepted responsibility, paid damages, around some 300 euro per person, but the parties did accept this type of settlement. With regard to detention, I have the same opinion as my colleague, because I was also a judge in a criminal department. We were very restrictive there. Yeah, we had quite a few violations there with regard to online trials. In very serious trials, our detentions, a 3-year deadline had expired because we didn't have possibilities for online trials. That's it. Thank you. Thank you, Anna. You see that we take over many things as a good practice from European courts. As you said, friendly settlement. 10 years ago, nobody would even think that case could be resolved in that way so quickly.
This session, I mean, are there any others who would like to ask questions, to comment? Because we are already, I think that most of our participants are hungry, and I don't want to be accused for Article 3. And so if you allow me, I will try to conclude this panel. But I will use opportunity to speak in my mother tongue, in Macedonian now, because I know that we have very good translation, and I will use this opportunity now.
I would love to thank you and to say my opinion. What is the protection of judiciary of extraordinary cases like pandemics, on conditions of terrorist attacks? It is very important. In this situation, a good part of people who are poor and they don't have their rights in these cases. And I think that in the future we are going to see the analysis to the time of the pandemics and the time of this time of all the crises in families. We had a lot of sexual attacks on children under 14, and we get a lot of cases of that nature, and how pandemics got involved in that. And we as judges, it is very important to follow the practice of EU rights and to continue without taking the conditions of pandemics, of emergency cases, to continue according to the standards and principles of a right judiciary. We are happy we have EU court, and we can sometimes we can learn from their experiences of other people, and not to make the same mistakes. I would love for you to have a good dinner. I think that Biljana is going to talk. 1:50, 1:15, please come back. We're going to continue. Yeah, 1:50. In 1:50, please come back.